Welcome to County Portal, your simple source for local government services and public records. Let's get started.
Does a criminal summons go on your record? This is a question that causes a lot of confusion, and the answer isn't a simple yes or no. Let's break it down. First, you need to understand what a criminal summons is. Unlike an arrest where you are physically taken into custody, a summons is a legal document, a piece of paper, ordering you to appear in court on a specific date to face a criminal charge. It's typically used for less serious offenses, like misdemeanors such as petty theft, disorderly conduct, or certain traffic violations. Now, does the summons itself go on your record? Not exactly. The piece of paper isn't the problem. The problem is what the summons represents, the official start of a criminal case against you. The moment that summons is filed with the court, a public court record is created. This means that anyone, including a potential employer or landlord doing a deep dive, could go to the courthouse or look up court dockets online and see that you were charged with a crime. So, in that sense, yes, it immediately creates a public footprint. However, what most people mean when they ask about their record is their permanent criminal history, the kind that shows up on a standard background check. This is where the outcome of your case is everything. Let's look at the possibilities. 1. If you go to court and are found guilty, or you plead guilty, then you will have a conviction. That conviction absolutely goes on your permanent criminal record and will show up on almost any background check. 2. If your case is dismissed, either by the prosecutor or the judge, the situation is much better. While the record of the charge might still exist in some databases, it will be marked as dismissed. This looks far better than a conviction, and many standard background checks might not even report it. 3. If you fight the charge and are found not guilty, the result is similar to a dismissal. The record shows the charge and the acquittal, proving your innocence in the eyes of the law. The most important thing to remember is that a summons is the beginning, not the end. Ignoring a summons is the worst thing you can do. If you fail to appear in court, the judge will issue a bench warrant for your arrest, and you'll have a new, more serious problem. The initial charge from the summons is what can ultimately become a permanent mark on your record, but only if it results in a conviction. This is why it is so critical to take any summons seriously and consult with an attorney. A lawyer can help you navigate the court system and fight for the best possible outcome, like a dismissal, which can prevent the charge from becoming a damaging part of your permanent record. So, the summons starts a process that creates a public court record, but whether it becomes a conviction on your permanent criminal history depends entirely on how the case is resolved. Thanks for watching. If you found this information helpful, please hit the like button and subscribe to our channel.